of Rights is a provision under the 1987 Constitution. Specifically, we can find this under Article 3. I'm not going to really dive into it. This is not for law students anyway, but these are only the basics of its provision. But I would like to start first, of course, with the concept of Bill of Rights. When I was still teaching in the undergrad and handling political science, I was then using Hector's de Leon. And I would like to impart also what's the context under the textbook that I was then using. So, as I could recall, Bill of Rights is the declaration and enumeration of a person's rights and privileges which the Constitution is designed to protect against violations of the government or by an individual or groups of individuals. So from this context, we can say that the Bill of Rights is not meant to be invoked against acts of private individuals. And before going to the first section, I would like to discuss the classes of rights briefly. There are several classes of rights. First would be the natural rights. From the word natural, these are the rights given to man by God as human beings. So examples of this from the word natural right is the right to live a happy life. These are even something that is inherent from the word natural. We have the right to love because we are human beings and God gave us that right. Another would be statutory rights. Statutory rights, from the word statutes, these are actually the rights that are granted as a product of enactment of the law-making body of the state. We also have constitutional rights. Constitutional rights are those rights granted by the Constitution. There are classifications actually of constitutional rights. There are so many of this. One would be political right. This is very important. These are those rights granted to citizens that give us the power to participate directly or indirectly in the establishment of the government or in the administration of the government. So of course, since we are in a democratic state, we are the sovereign people. We have the power to put those people in power, to give them the authority and trust our sovereignty to them. So we exercise this through our political right to suffrage. Now that's just an example. That's why it's very important for us really to vote, because that is a right granted to us by the Constitution. Another example of constitutional right would be civil rights. This is probably the most familiar one, because these are the rights which the law enforces at the instance of private individuals. Most of us are private individuals, and these are rights in order for us to be able to secure the enjoyment of our happiness, in order for us to reach our means of happiness. So example, of course, the very obvious one, freedom of expression. What I am doing also in YouTube, imparting to you some sharings about my thoughts, heeding to the request of some students and even some professors. I'm sorry for those who have been lined up anyway. I'm trying to give time to the rest of the request. But this particular expression of mine, this particular way of imparting my thoughts to you is already an example of what we call civil rights, enjoyment to the means of my happiness and happiness of the rest of the members of my family, because they would always ask me to, hey, come on, let's shoot. This is the idea, and then let's shoot. We'll give you the guide. Another right under the constitutional right is the social and economic rights. These go together. These include those rights which are intended to ensure our very well-being and economic security. And examples, what are examples of this one? As far as I could recall, the right to inherit property, the right to engage in business. These are examples of social economic rights. And of course, the rights of the accused. Obviously, they are still civil rights. Now, they form part of civil rights, but they are intended for the protection of a person accused of any crime. So basically, these are examples of the constitutional rights of persons. So we have several examples of classes of rights, and our concentration, not really the natural, not really the statutory ones, but our concentration would be those provided under the Bill of Rights. Okay, so Section 1, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. So basically, this is about non-deprivation of life, liberty, and property. And it highlights the aspects of due process of law, because you cannot be deprived of your life, you cannot be deprived of your property, you cannot be deprived of your liberty, but you can. There's no right that is absolute. You can be deprived of life, liberty, and property if there is what we call the due process of law. And what is this due process of law that we are referring to? There are actually two aspects of due process of law. The first one is the procedural due aspect. But I would like to discuss first the substantive. I always do this in my class before. Substantive simply refers to the law itself, that it should be fair, that it should be reasonable, and that it should be just. In other words, simply, no person should be deprived of his life, of his liberty, his or her property, for any arbitrary reasons or on flimsy grounds. What I'd love the most is the procedural due process. One legacy that a former faculty member, senior faculty member that gave me is actually the acronym HIT. So when I discuss due process, I would simply tell my student, I'm fine with using acronyms. So if you would like to understand due process of law, just remember the word hit. A law that hits, but remove the S. Basically, when we talk of grammar, we need the S. Diba? This is the subject-verb agreement. But HIT, I should have a board here. Next time, probably I really need a board, whiteboard next time to write. H is for, it's a law that hears before it condemns. So hear. And then I would refer to inquiry. It's a law which hears before it condemns. It proceeds upon inquiry, that's the I, and render judgment only after the letter T, which is trial. That's basically what due process of law is. It's important to define here the terms that we have. Like, for example, life. It's basic, but what really is life? How would you define life? In my discussions to my students, I really love asking them about what life is. And at times, even if this is a very elementary question, they would be having a hard time defining life. So if you are viewing right now, and if you are a CWTS student, how would you define life? Life is something about breathing. Usually this is the common answer that I would get. But basically, life is more than mere animal existence. Meaning, life is more than breathing. It means something more than mere animal existence. It's the enjoyment of what God gave to you. It's the enjoyment of utilizing all of the faculties that has been given to you by God. So it extends from the prohibition, the right to life extends from the prohibition against your deprivation without due process from all the limbs and all the faculties for you to enjoy your life. Now, what about liberty? You must not be deprived of your liberty. What do we mean by liberty? As protected by due process of law, it actually refers to merely or more than freedom from physical restraint. It's more than being put behind bars or imprisonment. And of course, property. So what do we mean here by property? As protected by due process of law, it may refer to the thing itself, that you own, of course, or your right to have a dominion over a thing. So you have the right to own property. You must not be deprived of the property that you own. But deprivation of property is more than depriving you or taking what you own. Even if you, for example, can no longer utilize that property of yours because there are other individuals or group of individuals that are using your property and you cannot utilize it, then that's deprivation of property. So what about equal protection of the laws? That's the second concept. So first, as I've mentioned, Section 1 highlights the non-deprivation of life, liberty, and property. And another highlight is the equal protection of the law. So we must be equally protected by the law. This signifies that all persons subject to legislation should be treated alike. But take note, this allows reasonable classification because we are not treated alike. For example, equal protection of the law would tell us that in case you are going to be taxed by the government, it should be proportionate in character. Meaning, if you are a lawyer of a government who enjoys, say, just an example, I'm not very particular about the salary grade. Say, for example, you enjoy receiving a salary grade of 26 and I am a teacher who falls under the instructor 1 level. Of course, in terms of what you receive, they're very different. There's a huge difference. So, taxes of the lawyer should be higher than that of the tax that is going to be imposed or extracted from the income of the teacher like me. Okay, that's for Section 1. I tried to shorten it already. And now, another important provision of the Bill of Rights is Section 2. By the way, if you memorize Section 1 Bill of Rights, it's just like you know your entire right already because it's about life, liberty, and property. Now for Section 2, the right of the people to be secure in their persons, papers, houses, and effects against unreasonable searches and seizures. They shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons to be seized. Very long provision. So what is important here is that you need to understand that you cannot be searched without search warrant, and you cannot be arrested without the warrant of arrest. So let's just define them a bit. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by the judge, okay, not by the mayor, else that is not a valid warrant or search warrant or warrant of arrest. This is actually directing a peace officer, commanding him or her to search for a certain personal property and bring it before the court. Now that is search warrant. If the command now is to arrest a person, then that is warrant of arrest. The person is going to be taken into custody in order for him to answer the accusation or the commission of the offense. The written order is called warrant of arrest. Okay, so that's the distinction between warrant of arrest and search warrants. And of course, there is a need to establish what you call probable cause. Now, it's important to understand and highlight the concepts of this provision. So what is this probable cause that we are talking about? Probable cause refers to such facts and circumstances antecedent to the issuance of a warrant sufficient in themselves to induce a cautious man, referring to the judge, to rely upon them and act in pursuance thereof. So before a warrant, be it be search warrant or warrant of arrest, to be given to a police officer, there should be a determination by the judge of the existence of what we call probable cause. So it will be examined carefully by the judge. So you cannot be arrested, you cannot be searched without warrant of arrest and without search warrant. But of course, there are exceptions. In its general sense, the law protects you, the provision protects you. You cannot be arrested without warrant of arrest. On what conditions? Under the rules of court, these would include, first instance, when you are caught in flagrante delicto, or when you are caught in the act. Meaning when you are caught committing the crime, or about to commit the crime, or have just committed the crime. That would already fall under caught in the act. And then another is you can be arrested even without warrant of arrest if the police officer is knowledgeable of the crime, has a personal knowledge of the crime, and immediately would arrest you in what you call hot pursuit, then you can be arrested without the warrant of arrest. Another is when you are a fugitive, meaning you have escaped from prison. If you are a fugitive, that would mean that you have been already convicted of the crime. So no need to ask for warrant of arrest. Now, what about search warrant? For search warrant, there are also exceptions. Of course, no person, even police officers, could just barge in, go inside your house without search warrant. But there are also exemptions. What are these exemptions? Okay, for warrantless arrest. So there are several instances also wherein you can be searched even without search warrant. For example, when you gave your consent, police officers went inside your house, you did not complain, then that would mean that you consented. That's waiver, you have waived your right already not to be searched without search warrant. Another instance is when an article, illegal article specifically, has been disclosed to plain view. Then you can be searched further. You can be searched even without search warrant. That's under the plain view doctrine. Another instance is for moving vehicles. The police, of course, cannot be expected to go and apply for search warrant before the court because it's a moving vehicle. The driver could already get away and evade from the police officers. So this is the third instance. And search can be made as an incident to a lawful arrest. For example, if a firearm is found and confiscated from a suspect being frisked, he can be charged already for illegal possession of firearm. And of course, he is already an accused by that time and cannot question the legitimacy of the search because it is an incident to a lawful arrest. Now, for Section 3, the discussion of Sections 1 and 2, they're quite long. Let's try to shorten our discussion. Section 3, there are two subsections. Subsection 1 states that the privacy of communication and correspondence shall be inviolable, except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So take note of that. We are entitled to our own privacy. If we would like to be left alone, then be it. If, for example, your colleague says, "Leave me alone," then you need to give that person privacy. That is his or her right. Do not eavesdrop also, it's not allowed. Do not wiretap, that is against the law. However, you cannot enjoy the right to privacy if there is a court order. It's not only, you can only enjoy that if there's no court order. You can also not invoke your right to privacy if public safety or order requires otherwise. For example, we have our Bank Secrecy Act, but your bank information can be divulged for public safety. Remember the cases of our public officials before wherein they cannot invoke the right to privacy simply because it's about public safety. But take note also, Subsection 2 states that any evidence obtained in violation of this, meaning of the section of what was mentioned or the preceding section, shall be inadmissible for any purpose in any proceeding. So we are talking here of inadmissible evidence. Example, if you illegally wiretap the conversation of drug pushers A and B without court order, you cannot use that in court because that is considered inadmissible evidence. Now let's go to Section 4. Section 4 is about your freedom of expression, enjoyment of your freedom of expression, your freedom of speech. It states, no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government of redress of grievances, or for redress of grievances. So, what is the highlight of this provision? It's important to define what freedom of speech is and what freedom of expression and of the press is. So, the constitutional freedom of speech and expression and of the press is otherwise known as the freedom of expression. It simply explains to us, or it simply refers to the right to freely utter. That's freedom of speech, to utter what you would like to utter. And freedom of the press is to publish whatever one pleases without previous restraint or prior restraint, and to be protected against any responsibility for doing so, as long as, of course, it is not in violation of the law, as long as it is not injurious to someone's character, reputation, or business. And it also includes the right to circulate what is being published. So basically, that is what freedom of expression is. So speech is therefore any expression, any form of your oral utterances. So be careful. Anyway, be careful of what you are uttering. And this would include even those of the motion pictures or movies. And the press covers every sort of publication, newspapers, periodicals, magazines, and books. Radio, television as an instrument of mass communication may also be included in the term. So that's freedom of the press. Section 5, what is this all about? Section 5 simply tells us about the freedom of religion. And it states, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. So, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall be forever be allowed, and no religious test, take note, no religious test shall be required for the exercise of civil or political right. Basically, that's a very important statement also in terms of freedom of religion, or when we talk of freedom of religion. So, freedom of religion is a constitutional guarantee which gives every man the right to worship God, the right to worship that supreme being, the one whom they believe as someone superior than them. And of course, to entertain, to express their own belief without dictation or interference by any person whatever. Religion, in its broadest sense, includes all forms of belief in the existence of superior beings, exercising power over human beings, imposing rules of conduct with future state of reward or of rewards or punishment. And of course, when we talk of freedom of religion, this would include your right to establish your own religion and become a member of such. But take note that you also have the right not to be compelled to. And there's no religious test. It's not allowed just for you to be able to be accepted in a particular religion. Section 6, which talks about liberty of abode and travel. Section 6 stipulates that the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court, and neither shall the right to travel be impaired except in the interest of national security, public safety, or the public health, as may be provided by law. What does this mean? Section 6 only highlights liberty of abode and travel. Liberty of abode and travel simply means your right to have your own home in whatever place you have chosen. And of course, to change it if you want to. If you want to live in Sulu, then live in Sulu, because you have the right to choose where you want to where you want to live, where you want to have your own domicile. And of course, the right to travel, your right to go and travel wherever you please without, of course, interference by the government. But there would always be exceptions, and that is if there is a court order. There is court order, for example, when you are an accused and you are to leave the country, then there could be a whole departure order. You cannot just leave because you are facing charges. And Section 7. What is Section 7 all about? It is the right to information. This is also the source of the right to information, because it stipulates the right of the people to information on matters of public concern shall be recognized. So, with this, you have the access to official records, you have the access to documents and papers pertaining to official acts, transactions, or decisions, as well as government research data used as a basis for policy development. And this shall be afforded to you as citizens, subject, of course, to such limitations, again, as may be provided by law. So take note, this would only be limited to matters of public concern. If it is something private, of course, you cannot access that. But it is not yet really full-blown because there's a need to have a statute. There were several attempts, but it is this government that came up with an executive order for it to be realized. So, if you are to recall, President Rodrigo Duterte already issued an executive order on the freedom of information. And hopefully, we will have a law on freedom of information already. What about Section 8? This simply refers to the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law. I would like to reiterate that. Not contrary to law. It shall not be abridged because that is a matter of right. You can form your own unions, you can form your own organizations, as long as it is allowed by law. Before the 1987 Constitution, the public sector, the government cannot just form unions. But there is also a limitation. For the private sector, aside from forming unions, they can stage a strike. The government is prohibited, the public sector cannot stage a strike. That is something which is very important that you need to remember in this section and in forming unions or associations or organizations. For what? So why is the government prohibited, considering that they are allowed already in here to form unions? Imagine if, for instance, police officers would stage a strike. People in the public sector cannot stage a strike because they are the ones that provide public services. And for Section 9, it states, private property shall not be taken for public use without just compensation. The statement is very simple. You have the right to own property, you have the right to your private property, and it cannot just be taken away by the government. But, of course, again, it has an exception because the government could exercise what we call eminent domain, or the power of eminent domain. When I discussed this in class, I also discussed the other inherent powers of the government, because it's not just about inherent powers of the government is not just eminent domain. We also have police power, and we also have the power of taxation. But for the purpose of this discussion, since this is a request for me to discuss what's in the provision, so I will just impart to you a little bit about eminent domain. So one of the inherent powers of the government is the eminent domain, which supports Section 9 of Article 3. Eminent domain is the power of the state or the government to take away private property. This has been lawfully delegated to the government, okay? So it is the power of the state to expropriate or take away private property on two conditions. One, if it is for public use, and second, if there is just compensation. If it is intended for private purpose, then the government cannot exercise its power of eminent domain. So, for example, if the government would like to construct a bridge in order to connect one barrio to another barrio, and a portion of your property or even your house, there's a portion wherein it will be affected, a portion of it is to be taken by the government, then that is for public use because it is going to connect one barrio from another. It's actually a bridge. It is to be used by the public. It's for public use. And of course, the government must give the private owner just compensation. That's the power of eminent domain. Okay, so this is just one of the inherent powers of the government. Section 10. Section 10 states that no law impairing the obligation of contracts shall be passed. Now, so the law-making body must not pass a law that would impair the obligation of contract. And obligation of contract simply refers to the law or the duty that binds the parties may it be two or more, to perform their agreement according to the terms stipulated in the contract or the intent in the contract. If it is not contrary to law, as long as it's not contrary to morals, good customs, public order, and public policy. Section 11 talks about free access to the courts and quasi-judicial bodies, and adequate legal assistance shall not be denied to any person by reason of poverty. So this is a very good provision because it actually highlights the free access of persons to the court. So this protects those people suffering from poverty. So the underprivileged must be provided with free access to the court. In view also of the social justice principle. Remember, Ramon Magsaysay, our former president, mentioned that those who have less in life should have more in law. So that is in view of the social justice principle, wherein you need to give preference to the poor, or the government should give preference to the poor. This is why their being poor must not be a hindrance for them to seek grievances, to file complaints in courts, especially when they are victims. That's very important. Or if they are going to become also the accused person, they need to be given free counsel. You know, there are so many constitutional rights of an accused person, and that is already what we are up to in the next section. Section 12 basically would start the rights of accused person. There are so many rights, you might say, but of course, the government needs to protect also even the accused person. The government has a very long arm. It's powerful. So part of Bill of Rights is also to protect the accused. So rights of the accused, first is under Section 12, wherein it states, subsection 1, a person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing or in the presence of counsel. When you are an accused person, you have the right to be informed of the nature of the accusation, the reason why you were arrested. That's just subsection 1. Subsection 2 states that there should be no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against the person or against him. secret detention, solitary, incommunicado, or other similar forms of detention are prohibited. So subsection 3, any confession or admission obtained in violation of this section, referring to section 12, or section 17, no? Section 17 stipulates the right against self-incrimination. So later we'll go to that. Any confession or admission obtained in violation of that section with a court order shall be considered also inadmissible evidence against the accused persons. And subsection 4, no law shall provide for penal and civil sanctions for violations of this section, as well as compensation to and rehabilitation of victims of torture or similar practices and their families. Let's have an example. Say Peter was caught in the act committing a crime and was therefore arrested. The police officers who apprehended him must inform him of his right to remain silent and to have an independent counsel. These are what we call Miranda rights. So that independent counsel or lawyer must be of his own choice, not Peter's choice. Now, if Peter would have an admission while he is under custodial investigation still, it will not be accepted in court unless if Peter would sign an affidavit or a waiver, meaning he waived his right to remain silent at that point and do the confession. Or say another suspect is being interrogated by the police, and that suspect voluntarily, without being forced, admitted his crime and even revealed the location of the murder weapon which he used in killing another person, but that is without his counsel, and he did that without waiving his right to remain silent. The prosecution cannot use that evidence before the court. That is considered, or that is what we call extrajudicial confession. So if that is the evidence that is going to be used by the prosecution, it's not accepted. And if the prosecution cannot produce substantial evidence other than that, then the court must acquit the person. Now, Section 13. Now, this is probably familiar to most of you. This talks about the right of persons to bail, or the right of an accused person to post bail. And it states, all persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong. Take note, when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties or be released in recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended, and excessive bail shall not be required. So we'll be discussing the writ of habeas corpus in a bit. Let's discuss and concentrate on the right to bail. So let's define the word bail. So bail simply is a security required by a court, and this is used for the temporary or provisional release of a person who is in the custody of the law and conditioned upon his appearance before any court as required under conditions that have been specified by court. The bail serves the interest not just that of the accused but even that of the court. The bail serves as an insurance for the court to compel the attendance of the accused during hearings. Because if the accused fails to attend hearings, then the bail will be forfeited in favor of the government. So basically, that's for the interest of both parties. However, an accused cannot post bail, as clearly stated in the provision, if the crime charge against him is punishable by reclusion perpetua, life imprisonment, or death. Of course, if there's death penalty. The highest right now, the highest penalty is reclusion perpetua. Life imprisonment is the English translation of the Spanish reclusion perpetua. But they are not the same. No, technically, they are not the same. Reclusion perpetua carries with it a subsidiary penalty. It's not just imprisonment per se, like life imprisonment. So when the punishment is reclusion perpetua, it carries with it, for example, a subsidiary penalty like the accused person, once convicted, can also be deprived of the person of his right to vote. Okay, offenses that are not available, the heinous crimes, those that are considered to be capital offenses, such as rape, murder, and kidnapping. So these are non-bailable cases. But again, not the I have emphasized a while back, even if a case is non-bailable, if the prosecution fails to prove that the evidence of guilt is strong, the court may allow the posting of bail by the accused. If you're going to talk about former Senator Enriquez's case, you might be interested. It's a different thing. His release or posting of bail, it's more of a humanitarian reason because of his age. And then we have section 14, which talks about the rights of the accused not to be held to answer of his criminal offense without due process of law. I'll just explain this. No, it's another long provision like that of section 12. So the article further provides that in all criminal prosecutions, the accused shall be presumed innocent until contrary is proved. As we've mentioned, there should be trial. It should be through due process. And I have explained what due process is already. So you give the accused the right to be heard by himself, of course, and by his counsel. So there should be a defense counsel. At this point in the process of arraignment, the person is going to be informed of the nature of the accusation that has been charged against him. And under section 14, it also provides that the accused has the right to a speedy, impartial, and of course public trial. There's no such thing as private trial. It cannot be done. And in this process, he has the right to meet the witnesses also face to face, and to have compulsory process to secure the attendance of the witnesses and the production of evidence, of course, on his behalf. In compelling witnesses, there is a need for the court to issue subpoena. If it's a document or a document that is going to be presented before the court, then we call that subpoena duces tecum. So you produce the document before the court. Now, after the arraignment, trial may proceed notwithstanding also the absence of the accused. We also have what we call trial in absentia, in the absence of an accused person. However, it can only happen, trial in absentia can only happen when the accused has been duly notified, that's one, and second, his failure to appear is unjustifiable. Section 15, it talks about the privilege of writ of habeas corpus, the non-suspension of the privilege of the writ of habeas corpus. Of course, except in cases of invasion or rebellion, and again, when the public safety requires it. So, what do we mean by this writ of habeas corpus? From the word habeas, meaning an order in writing, and corpus, body. So, the writ of habeas corpus simply tells us that it is an order in writing to produce the body of a person being detained. So, this is issued to a police officer or an officer holding another person in his or her custody. And this is a process that would command him to produce that prisoner, the person under his or her custody, at a designated time and place to show sufficient cause for holding the person in custody. So, if there's no sufficient cause, then the person should be released. The person must not be detained. And that privilege, as I've mentioned, can only be suspended in cases of invasion, rebellions. Okay, section 16 now. So on speedy disposition of cases before all judicial, quasi-judicial, and administrative bodies. So, as I've mentioned, this is an embodiment of the principle justice delayed is justice denied. And I have discussed this in one of my videos. That's actually my first video. A request also of a student. Please watch. The title is Tidbits of Innovations in the Philippine Justice System. To learn more about the speedy disposition of cases, please watch that video. Section 17 talks about the right of a person against self-incrimination. It states no person shall be compelled to be a witness against himself. So in most hearings, even in Congress, the persons would say, I have the right, I would like to invoke my right against self-incrimination. So simply, it means that you cannot compel or force anyone to be a witness against himself or herself. Section 18. Subsection 1 states that no person shall be detained solely by reason of his political beliefs and aspirations. So this protects persons with different beliefs. So they cannot just be detained just because they have different political beliefs, they have different political aspirations. Now these cannot be the reason why you are going to be arrested. So if there's a police officer arresting you and bringing a warrant, no, and telling you that the case is because you have a different political belief or different political aspiration, the Constitution protects you under Section 18. And subsection 2 also states that no involuntary servitude in any form shall exist except as punishment for a crime whereof the party has been duly convicted. So that is the right against involuntary servitude. Involuntary servitude actually denotes a condition of being enforced, no, or undergoing compulsory service. So it's rendering of service against your will. Specifically, it is of two kinds. It could either be slavery or peonage. Slavery is the state of being entirely subjected to the will of another. You perform services against your will, as I've mentioned, being subjected to another. That is against the law. And another one is peonage. Peonage is the voluntary submission of a person to the will of another because of his death. No? So that's not also allowed. So you cannot just say that, okay, I will become your servant, I will serve you for the rest of my life in order for me to be able to pay my debt. So it's not allowed. Section 19 simply tells us about Section 1. First, excessive fines. No? Excessive fines must not be imposed as punishment. There should be no cruel or degrading, inhuman punishment also. It must not be inflicted against any person. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. Now, if that is going to be, again, revived, the Congress hereafter, as stated in that provision, should provide for it. So any death penalty, it states, already imposed shall be reduced to reclusion perpetua. Subsection 2 tells us about the employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. So those are not allowed. Section 20 talks about our non-imprisonment simply because of our debt, failure to pay our debt, or non-payment of what you call a poll tax. Debt or utang, as intended to be covered by the constitutional guarantee, refers to any liability to pay money arising out of a contract, whether it's expressed or implied. So you cannot just be imprisoned simply because you did not pay debt, especially if you cannot really afford to. This is to protect poor people. The same as true if you fail to pay your poll tax. This is different from other types of taxes. If you fail to pay this one, you cannot be charged of tax evasion because this is a personal or capitation tax. It's a tax of fixed amount imposed on individuals residing in a particular territory. So if you're familiar with community tax certificate, not everybody would really get that, especially if you are really having a hard time earning your livelihood and you are still going to be obliged to pay that one. So whether you are citizen or not, without regard to your property or your occupation, if this is similar to the cedula. And section 21 states that no person shall be put twice in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. Simply, it talks about the right of an accused against double jeopardy, which means that when a person has been charged with an offense and the case has been terminated, either by acquittal or by conviction or in any other manner without the express consent of the accused, the latter cannot again be charged with the same or identical offense. So, double jeopardy, or the right of a person against double jeopardy, is a protection against second prosecution for the same offense after acquittal or conviction. So, once the case has been dismissed, that should not be filed again. For example, let's have a concrete example. For instance, a robbery victim may not file, therefore, 3 complaints for special complex crime of robbery with homicide, crime of murder, and crime of grave theft involving the same incident against a person. Why? Because murder is necessarily included in the crime of robbery with homicide, and the employment of threat is a means of committing robbery already. Therefore, the latter crime already absorbed the former. When the case of an accused has already been dismissed, for instance, let's say the accused was acquitted, and because the accused was acquitted, you are really angered, so you're going to refile the same case in the same court, then that is already double jeopardy. It will not be allowed. So if you're not satisfied, for instance, with the decision of the court, then you can go to a higher court, the Court of Appeals, until you reach the Supreme Court. But once it is already the Supreme Court that has laid down its decision, then it is already final and unappealable. Except if the sentence is death penalty, but you don't have death penalty right now. That will undergo automatic review. And so, let's now have the last section. It provides that no ex post facto law or bill of attainder shall be enacted. So, there are 2 focus in here. Ex post facto law. What do we mean by this? It means it becomes an ex post facto law when it makes an act done before the passage of the law innocent when done, criminal, and punishes such act. Simply, it aggravates a crime. When we talk of a law, when a law has been enacted, it should always be prospective in nature, futuristic. If it took effect today, the crime that has been committed yesterday, that covers a particular punishment which was just took effect, as I mentioned today, it will no longer cover that of yesterday, because it would change the punishment. And how would I simplify that one? In terms of punishment, it is also considered an ex post facto law if the punishment is greater than what the law annexed to that crime when it was committed, when it inflicts a greater punishment, or it alters the legal rules of evidence and receives less testimony done or different testimony from what the law required at the time of the commission of the offense in order to convict the offender. So that's basically ex post facto law. There's a classical case on this, a very controversial case on this one, the Visconde massacre. That was the case at the time when it was committed. Death penalty is not the highest penalty. But when it was decided, death penalty has been enacted. And therefore, some people who do not really understand the context of the law, they were very, very angry They have that wrath, but because they are expecting that Hubert Webb, who was the accused at that time of that crime, together with his colleagues, were not punished with death penalty. But the case is, if they will be punished with death penalty, then the law would retroact, and that would be considered ex post facto law. Let us have a vivid example on this one. Anyway, this is already the last provision. Say, for instance, during the term of President A, there was death penalty, and he was replaced by President B, and a crime was committed by Pedro when there was death penalty. So let's have a different case. The crime was committed when death penalty was existing, and that is the punishment of the crime committed by Pedro. But when the crime has been decided, there is no more death penalty. But it's not death penalty. Now, that was the punishment of Pedro after he was proven guilty. It is reclusion perpetua, lower than that of the death penalty. Why? Did it not retroact? It should be prospective in nature, as I've mentioned. There is an exception. When the law is favorable to the accused, it could retroact without being regarded really as ex post facto law. It's not considered a violation when it is favorable to the accused. Why? Because we have defined ex post facto law as something that would inflict greater punishment. And if you're going to inflict that punishment during the time when it was committed, it's death penalty, and there is an existing lower penalty, then that would be ex post facto law, because you're going to inflict a greater punishment. That's another interpretation of that. Or clearly, in simple ways, it's favorable to the accused, therefore it's not considered to be an ex post facto law. Now, the last term is the Bill of Attainder. A Bill of Attainder is a legislative act which inflicts punishment without judicial trial. That would be against the due process of law. So therefore, you cannot just inflict punishment without undergoing judicial trial. And that's the last section. So there should be no law, no ex post facto law, and no Bill of Attainder that shall be enacted. So if you were inspired by this video and learned something from it, it is quite technical. I discussed this for how many meetings? For 4 weeks, but I really tried to summarize it as requested because I have a different audience in here. So please like this video, comment down below, subscribe, and hit the notification bell for you to be able to receive updates from the moderator.